direct and prosper the deliberations of the Legislative Assembly now assembled, that all things may be ordered upon the best and surest foundations for the glory of thy name and for the safety, honor, and welfare of the people of the Cayman Islands. Bless our Sovereign Lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established amongst us. Especially, we pray for the Governor of our islands, the Premier, the Speaker of the Legislative Assembly, the Leader of the Opposition, Ministers of Cabinet, ex officio members, and members of the Legislative Assembly, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for thy great name's sake. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make his face shine upon us, and be gracious unto us. The Lord lift up the light of his countenance upon us, and give us peace now and always. Amen.
We now call on the Deputy Governor to be sworn as temporary ex-official member.
I, Eric Lennox Bush, do swear that I will be faithful and bear true allegiance to Her Majesty, Queen Elizabeth II, her heirs and successors, according to law. So help me God. I, Eric Lennox Bush, do swear that I will well and truly serve Her Majesty Queen Elizabeth II, her heirs and successors, and the people of the Cayman Islands in the office of ex officio member of the Legislative Assembly. So help me God.
On behalf of this honorable house, I welcome the honorable temporary ex-officio member and invite him to please take a seat. Please be seated. Proceedings are now resumed.
Reading by the Honorable Speaker of messages and announcements.
Madam Clerk. There are no messages or announcements.
Presentation of petitions.
There are none.
Presentation of papers and of reports.
There are none.
Question to honorable ministers and members of the cabinet.
There are none.
Statements by honorable members and ministers of the cabinet.
There are none.
Personal explanations.
There are none.
Obituary and other ceremonial speeches.
There are none.
Raising of matters of privileges.
There's none.
Other business, private members' motions. Private members, motion number 4 of 2015-16, motion on mortgage legislation, to be moved by the elected member for Northside and seconded by the elected member for East End.
I now call on the honorable member from Northside to move the motion.
Thank you, Mr. Speaker. I beg to move private members' motion number 4 of 2015-16, motion on mortgage legislation. Whereas many Caymanians are experiencing difficulties with their mortgages and in some cases are losing their equity in the current foreclosure regime. And whereas there is no current mortgage legislation in place, be it therefore resolved that government consider the enactment of mortgage legislation that will offer proper protection to the lending institutions, but will also provide property protections to the borrower as well, and in particular their equity.
Is there a seconder?
Mr. Speaker, I beg to second the motion.
The question is that be it therefore resolved that government consider the enactment of mortgage legislation that will offer proper protection to the lending institutions, but will also provide property protection to the borrower as well, and in particular their equity. Does the honourable member wish to speak thereto?
Yes, Mr. Speaker. Mr. Speaker, over the last few years, I have had lots of representation from within my constituency, as well as from the wider Cayman, of persons who are losing their houses. And while they and I understand that the lending institutions who finance these houses must have the right to recover their money, and if it boils down to having to sell the property, to do so. There are many instances reported to me which tends to suggest that it's a one-sided operation and that the lending institutions have all of the authority and in many instances doesn't seem to have any social conscience at all. And the unfortunate part of this, Mr. Speaker, is that the majority of these people are not young people under 30. Many of these people are in their twilight of their careers, middle-aged people, 45, 50, 60 years old. I have seen instances where one of my constituents had a 15-year mortgage and had made their payment every single month on time for 10 plus years, but the bank was now foreclosing and taking away their house because the person had lost their job due to downsizing, and because of the ease of these financial institutions getting work permits, was unable, although qualified and experienced, to get a similar job in order to continue to service their mortgage. And Madam Speaker, in asking the government to do specific mortgage legislation, I fully understand and expect that such legislation should offer adequate protections to the lending institutions. And nowhere am I trying to say that the lending institutions shouldn't have final authority to recover their funds. But, Madam Speaker, and I will give a few examples later on in my contribution, I have seen examples where people are losing hundreds of thousands of dollars in equity on the foreclosure. And it can't be right, Mr. Speaker, that a lending institution will insure a property for close to $500,000 in 1 year, because they are financing the insurance and adding it on to the mortgage payment, which that's a separate problem that we need to deal with. And then a year later, when they foreclose, they get some quantity surveyor to value the house at less than $250,000, and they even sell the house for a value below that evaluation. No, they get them. They go out and they hire the evaluators, and that again should not be allowed. Well, I'll get to that later on, and you tell me whether they instructed them or they're begging them. So, Madam Speaker, if many of these middle-aged people were able to retain their equity, if the house was sold at a proper value, they could start over. They could go and build a smaller house. And then many of these banks, Madam Speaker, are setting these people up for failure because they're allowing them to borrow all this money, overextend themselves over extended periods, and when they get in trouble, then they're all too happy to take it away and recover what is owed to the bank. And the person gets a zero for the equity. And, Madam Speaker, Mr. Speaker, sorry. Creature of habit, Mr. Speaker, my apologies.
Accepted.
Mr. Speaker, the banks or the lending institutions in such mortgage legislation, as I said earlier, must retain the ability to recover what they have lent or invested with the people. But it also, and mortgage legislation, it would not be unique. In fact, I think Cayman Islands is probably one of the few developed countries, as we like to call ourselves, that doesn't have mortgage-specific legislation. Canada has a long history going back to early 19th century. Jamaica next door has some mortgage rules and stuff. UK has extensive rules and regulations on mortgage. In fact, Canada has amended theirs as recent as 2012, and I think the UK has done some recent amendments to their legislation as well to bring it more in line with the EU. So I'm not asking here for us to invent the wheel. But Madam Speaker, we also, I believe, need to be bold in such legislation that we tend to introduce, and we should incorporate in that legislation the ability for the lending institutions to take equity for default payments, as opposed to simply foreclosing and because the object here has to be to help Caymanians stay in their house and the home that they've built. So the lending institution should be able to take equity, which would also serve two purposes, because they will be more likely to sell it at true value because they want to get their equity in addition to the balance on the loan, but the people stay in the house, even allow them to rent. And we should not be afraid to introduce what some countries, what the US I think calls reverse mortgages, particularly for people at this age, and in the UK I think they call it equity release, where senior citizens can borrow up to 80% of the value of their house on a prepayment basis, and when the house is sold at the time of their death, the lending institution gets its money back. So, Mr. Speaker, I believe that it is time for the government to look at this, and also I believe that if we championed ourselves as one of the leading financial places in the world, we should have expertise locally that can draft this kind of legislation and bring in these kind of new concepts and get it accepted so that we offer some protection for our Caymanian people. Now, Mr. Speaker, here are some of the cases that I've been presented with so that the public understand that the government needs to do something here. I have one case presented to me where they had a valuation by DDL for $515,000 in 2009 when the property was mortgaged. 2013, charter land for the bank valued it at $350,000 when this person started to get in difficulty of default. Then the owner went back to DDL in July 2014 and got a valuation of $465,000. JEC valuation in September 2014 was $550,000. The DDL itself did a valuation for the bank in May 2015, $465,000. The bank sold the house for $299,000 in May 2015. So that Caymanian lost between $51,000 and $166,000 in equity, depending on which one of those higher evaluations you want to take. I have another case, and the 299 was quite close to what was owed to the bank. Now the case had an evaluation for a 4,500 square foot two-story house, $497,000. Charter land evaluation saying the house was only 3,600 square feet, $250,000. The bank sold the house for $250,000 though. And the difference in the square footage, is the upstairs. That person lost $247,000 in equity. And this one I followed through the land registry, only to find that the land registry accepted the $250,000 for stamp duty purposes and the incorrect square footage of the house, because they looked at an aerial photograph. And of course, in an aerial photograph, the upstairs wouldn't necessarily show up. We have another case where you had an evaluation for the owner for $550,000. Evaluation for the bank, $280,000. Bank sold the house for $299,999. I wondered why all these nines, but I believe, Mr. Speaker, that the ceiling for the waiver of stamp duty for government, I believe, is $300,000. So this one was sold for $1 less, so they could qualify for the stamp duty waiver. And I believe I am correct in saying is that they got the stamp duty waiver. So, Mr. Speaker, I use those examples just to show that there seems to be great variation. And one of the things that seems to be happening, which in my view the legislation should stop, is that the banks seem to be selecting their valuators, and that should be an independent process. Or if you go back to the court records, you will see that in years gone by, when the stuff always went to court, and court set a reserve price. They used to take the median of the evaluations and agree on amount. But because of a practice directive number 5 issued in 2012, wherein it seems that because there were different interpretations of what our registered land law required, you had different judges given different interpretations to the rules, and the Chief Justice, in trying to bring some commonality, some judges were very difficult on the lending institutions to take away people's houses, and others were more liberal in allowing them to do it. So in an effort to, I assume, to bring it to some kind of consistency, the Chief Justice issued Practice Directive number 5 of 2012. And he said, in recent past, practice directives on application under Section 72, 75, and 77 of the Registered Land Law. And he said in that practice direction, in recent past, a number of decisions of this court have dealt in different ways with the subject of applications under the RLL, which is a Registered Land Law, for leave of the court to enforce charges under the Registered Land Law by way of sale by private treaty. These practice directives seek to explain the practice of the court which has emerged as a result of these decisions. Typically originating summonses seek the following kinds of relief or variance thereto. A declaratory relief to the effect that the defendant, charger, is in default of payment under the charge. 2, that the charge be enforced by sale of the property by way of public auction or private treaty, acting in good faith and having regard to the interests of the charger. 3, that a reserve price be fixed for the sale by way of private treaty. 4, that the property be listed for sale on the Cereba multi-listing system. 5, the terms and conditions of the sale be determined, if any. 6, that leave be granted to issue a writ of possession with respect to the property. 7, alternatively, that the chargee be given reasonable access to the property for the purpose of viewing or for any other purpose in connection with the chargee's effort to sell the charged property. And 8, cost. Whether or not any aspect of relief is granted will, of course, be a matter of the exercise of the discretion by the court, having regard to the particular circumstances of each case, including the conduct of the parties. See Section 77 of the RLL, National Building Society versus Cranston, 2011, and the Bank of Butterfield Cayman Limited versus Thornton and Thornton, cause number 307 of 2010, written decision 29 of March 2011, where the chargee has the power of sale under the charge and has complied with the requirements of the RLL for the giving of notice, the jurisdiction of the court to exercise its discretion to vary or add to the provisions of Section 75 of the RLL to allow the chargee to sell by way of private treaty in addition to or instead of by way of public auction will not be in dispute. Section 77 provides that the parties to a charge may vary or add to the provisions of Section 75, provided that such variation or additional shall not be acted upon unless the court, having regard to the proceedings and conduct of the parties and the circumstances of the case, so orders. Factors of importance to the exercise of the court's discretion will include that the property must not be sold at any undervalue. Paradise Manor Limited was Bank of Nova Scotia, 1984, 85, Bank of Butterfield Cayman Limited versus Jervis and Jackson. B, that the sale has to be in good faith. And Mr. Speaker, for brevity, I will not quote the cases because they're not really relevant to our discussion. C, the best evidence of market value is the reaction of the market. D, the standard of care required of the chargee, that of a reasonable man in respect of the conduct of his own private affairs. E, leave to sell by private treaty at a reserve price set by the court will not usually be granted without previous attempts to market the property and to sell by public auction on the open market. F, however, leave to sell by private treaty may be granted where there has been no prior attempt to sell by a formal public auction where the court is satisfied that it is in the interest of justice so to order, especially bearing in mind that a formal public auction could add unnecessarily to the cost to be ultimately passed on to the charger. The order will usually be conditioned as subject to the chargee acting in good faith and having regard to the interests of the charger. G, sale by public auction does not necessarily require a formal auction conducted by an appointed auctioneer, but in substance, the sale of a property through the MLS is a public auction. H, before leave to sell by private treaty at a reserve price set by the court will be given, there will usually be, to the satisfaction of the court, evidence at least of attempts to sell by way of public auction by listing on the MLS at a reserve price set by the chargee aimed at realizing the true market value. I, the sanction of the court of a price obtained whereby by public auction, by listing on the MLS or otherwise, or by private treaty, is more likely to be granted where the price has been set by the chargee by reference to an independent valuation. In this way, the court will be more likely to conclude that the chargee has acted in good faith in exercise of its rights under this charge. J, there is no need for an application to the court for placement of the property for sale by public auction, whereby by way of a listing on the MLS or otherwise, in the first instance by the chargee, who by virtue of the powers given under the charge, Section 75 of the RLL, can sell by way of public auction without the leave of the court. K, an application to the court is necessitated only when leave to sell by private treaty, whether by fixing of a reserve price or otherwise, is required by way of a variation of Section 75 of the RLL as agreed in the charge loan agreement. L, where the court considers that a chargee has brought on unnecessary application for leave to sell by public auction, the court will refuse to grant an order for the cost of so doing. Other factors which the court will consider will include: 1, the defendant's position and whether they have notice of the application. 2, whether the defendants are represented and have a proper understanding of the application. 3, is there any element of unfairness or unreasonableness in the chargee's application? 4, whether an order for cost should be imposed upon the charger over and above any right that the chargee might have to recover cost under the charge loan agreement. And Madam Speaker, many of the, Mr. Speaker, I'm going to keep looking at you, sir, I'm sorry.
No problem.
Many Caymanians feel that that directive allows the banks to just go to the MLS listing without going to the court and having a reserve price set. And they believe that that gives the banks an opportunity to appoint their own valuator and to get valuations very close to the balance owed to the bank in order to sell the property. And they believe that in some instances, the lending institution is not necessarily exercising its authority under the law by advertising the property, because a lot of this seems to be done through particular real estate agencies who seems to have a list of clients lined up to buy these properties. And Mr. Speaker, even when the court has in past set reserve prices, I'm aware of at least one instance where the court set a reserve price of $750,000 for a large two-story house, concrete house on 10 plus acres of land. And the bank made a private treaty for 500,000 US and sold the property for 500,000 US, even though there was a reserve price of 750,000. Of course, the client thought that if the bank sells my house and property for less than it is, they're taking the loss and I'm out of debt. But of course here, and again, I think that mortgage legislation we bring in should not allow the banks to allow personal guarantees above and beyond the value of the property. Because what happened in that case was the bank charged another one of his properties for the difference in the price and wound up taking that as well, because they also sold that by private treaty for a lot less than the real market value. And then they placed that remainder on a third piece of property. And Madam Speaker, Mr. Speaker, sorry, I understand fully that in most of these cases, it is the person who borrowed the money who gets in trouble, because oftentimes they use funds that they have to do other things, like going on vacation, etc., rather than paying the bank. But that does not, in my view, negate the fact that, as that practice directive by the Chief Justice says, when the bank decides to take possession of the house and sell it, they should get the maximum amount that they can get for the value, and not just near to what the bank needs. Because as the cases I made a while ago, it can't be that, whether, as I understand how they value people, they use either replacement costs, construction costs, or they look at similar sales within that area to come up with a valuation. It can't be that $200,000 variation if these people are conducting these valuations with any kind of professionalism at all. But we all know that in some of those companies, when you call them for an evaluation, the first question they ask is how much you need to be valued for. And we need to, the legislation, if the government decides to bring legislation, which I certainly hope they will, should say that these valuators must be independent and it can be proven that they're arm's length from the bank, and also from the person who owes the bank the money. Now, Mr. Speaker, I have a petition to members of the House which I want to read into the record, and I will table it because it was not prepared in the way to present a petition, and because, you know, those under our antiquated standing orders, which finally we're going to get committed to review them, and I hope we can get that done now before Christmas by the government, and that's not going to take forever again, and a day. Requires that things be handwritten and all that sorts of stuff. So I told them, when they came to me with it, I told them I would read it into the record and table it. This is a group of citizens, most of whom have been affected by this foreclosure business, because if you talk to some people, they will tell you that the real estate companies are largely now not in the real estate market to sell new properties. A lot of them are in the foreclosure business. And they're deliberately going out and assisting with these foreclosures. And while I will not go as far as to say that there is collusion, Mr. Speaker, I would say this much, that it's close. It's close. And because if you look at the companies involved in this, the law firms, the evaluators, and the real estate people, there seems to be a commonality, and others seem to be getting more business than others. But let me read this. It says, petition to members of the House. To the Honorable Premier and members of the Legislative Assembly of the Cayman Islands. The petition of the undersigned concerned Caymans, organized as members of an informal group, Caymanians Against Economic Injustice, respectfully showeth that many Caymanians are being disenfranchised of their rights to family life due to unfair financial, structural, and systemic laws, judgments, regulations, and practices. Concerns that the current rate of unemployment and underemployed Caymanians, many of whom are single parents, are enduring the loss of income resulting in foreclosure, loss of personal property, and their family home, breaking up family units to the detriment of minor children, disabled family members, elderly, and all ages. That the effective enforcement of labor laws is leading to unfair discriminations against Caymanians, thus creating loss of income to service their debt obligations. That the banking, open loans, mortgages, laws, and regulations which local borrowers follow are tantamount to predatory lending practices, and we believe lack fairness and consistent application to all customers. And there must be priority and enforcement of the Constitution Order 2009 Bill of Rights Part 1 that guarantees our rights and responsibility to pursue economic, social, and cultural development, specifically Section 9, private and family life, and Section 16, non-discrimination. Proposed solution, banking rules. Amend the banking rules by addressing foreclosure procedures to ensure jurisdiction remains in the Cayman Islands, where the mortgage or property, source of payment are all located in this jurisdiction. And I'll speak to that one in particular, Madam Speaker. Mr. Speaker, immediately remove, revoke, or amend the draconian legislation and inequitable banking practices which many banks use to continue commencement of court action after 3 months of consecutive arrears. 3. Adhere to the Cayman Islands Bankers Association Code Section 14, Directive to assist mortgagors. It is proposed that there be consideration and application of similar rules of Chapter 13 Bankruptcy Foreclosure Laws of the United States for local banking regulations, specifically to allow arrears of 3 months or more to be handled as a separate loan or to be repaid within 3 to 5 years, leaving the mortgage property to maintain its equitable right to be redeemed by the mortgagor borrower. 4. Mandate the banking laws that no one is to be barred from negotiating a mortgage loan credit facilities after 2 to 5 years where a Caymanian has gone through a foreclosure, repossession, bankruptcy in the past. 5. Change Cayman's hybrid system, now arguably a mix between the US and the UK, and adopt a system in relation to foreclosures, repossession to reflect protection for private family-occupied homes that meet the needs of our people in this jurisdiction. We respectfully petition legislators to show some originality and courage in this regard. In truth, copying our competitor jurisdictions might be practical in other financial matters, but not in arrears that affect our social and economic environment in a detrimental manner. 6. We further propose banking laws reflect similarities to that of the UK in that all mortgage agreements include a personal protection insurance scheme to deal with common life challenges, including job loss, loss of one partner's income through death, divorce, disability, or other occurrences, when sensible, manageable premiums instead of the current draconian amounts may find impossible to pay. Many find impossible to pay. We are aware of the impact of global policies, procedures from insurance companies, but would advocate further investigation into the level of premiums and the lack of benefits to local policyholders. The Supreme Court of Justice has just awarded billions of pounds to homeowners who were ripped off through extortion by insurance providers who paid commissions as high as 40 to 60% to agencies who sold for them, which got tacked onto homeowners' premiums. It is not fair that of the two parties to the insurance contract, the bank's risks are covered, but the homeowners who are paying the premiums cannot claim to cover their unforeseen but reasonable risk over the period of 15 to 25 years. Pension law. Pension laws can be temporarily amended to allow Caymanians facing immediate foreclosure or currently in arrears, or when foreclosed, to have immediate access to their pensions to clear arrears and reinvest in local property without having to relocate overseas to access pensions after losing their properties. 8, our government representatives, trustees of the people, should examine how much money our economy will actually lose by the exodus and impact that it will have on the economy when pension holders choose to take early retirement at age 50, withdrawing their maximum entitlement per year to establish themselves in another country. They can return to Cayman, get back in the workforce, and the process is repeated, therefore bleeding Cayman's economy again and again when they reach full retirement age, when they could prove to be a greater burden on the financial assistance system if they decided to remain on island, at which time pensions would be depleted. So it is better to allow foreclosed pensioners to use their funds to establish security in their own country. Should not affect terms and conditions in legally binding documents that were in effect prior to directives by the Chief Justice. We seek clarification on the rules, directives which might be contrary to or less than rights under our Constitution, and as such, any charges should effectively be brought about by legislation. We suggest that the approved government guarantee mortgage 35% plan could be used in the case of arrears by government issuing a letter of guarantee to the involved banks, which would fall away once the arrears have been fully repaid by whatever means the mortgagor pursues and secures. Government can register a second charge on the property for security for the amount guaranteed. The principal could then be refinanced for a period resulting in payments more manageable than previously agreed. Wherefore, your petitioners pray that your Honorable Assembly will grant to the Caymanians against economic injustice group the investigations, reviews, considerations of our rights, and make necessary amendments as pleaded above to promote and enforce non-discriminatory practices in order for Caymanians to have access to family life, property rights, and financial and economic well-being. And this is signed by 8 persons, Mr. Speaker, and I table it so that all members can get copies.
So ordered.
Now, Mr. Speaker, in researching the laws in Cayman, I found where the Cayman Islands Monetary Authority and Supplement 1, Gazette number 5, Rule Management of Credit Risk and Problem Assets, Statement of Guidance, Credit Risk Classification, Provision and Management. But this deals mostly with the bank itself and doesn't offer any protections or consideration for the client, and also the regulatory policy on licensing banks. And one of the things I found very interesting in this document, which was published in Gazette number 18, September the 8th, September 2014, was, and a lot of us have been experiencing these banks, and everything now is buried under Know Your Customer policy. And I digress, but I'll just give you my most recent example, Mr. Speaker. Last Tuesday, I went to the bank and took out $42 to buy 50 US because I was traveling 7 o'clock the next morning. Went to the counter and said I'd like to buy $50 US. No, sir, you can't do that. What do you mean? This is CI money. This is legal tender. No. You can't buy US like that. No, you have to deposit the money back into your account, right? Then you have to do a withdrawal slip for the US out of the CI account, and you get the money. Mr. Speaker, that had nothing to do with know your customer according to this regulation, but that's what they tell you it is. That's just so they can charge you. They already charged me for taking it out of the ATM, you know. Then they charge me for depositing it. Then they charge me for buying the US. Then they charge me for the withdrawal. Now, we know that the banks are not making the kind of profit they were making in the 80s and 90s on interest rates and stuff like that. But some of the things they're doing now to people in Cayman in particular. And you know, the most interesting part of that, Mr. Speaker, is I had reason to open an account in the US. And the whole thing was completed in less than half an hour. Included my debit card to walk out, and all I had was one passport picture. Didn't have no job letter, no police record, no nothing. You go here, a bank that I've been dealing with since I left high school, and that's too long ago to identify it right now, Mr. Speaker. They want my passport, they want a job letter, everything under the sun, police record. Why? Because this is what the Monetary Authority says about know your customer policy. The applicant, meaning the bank, must demonstrate how it will comply with the requirements of the Proceeds of Crime Law as amended, the money laundering regulations as amended, and demonstrate adequate policies, procedures, and systems consistent with the guidance notes on the prevention and detection of money laundering in the Cayman Islands. So, Madam Speaker, while we seems to be, and successive governments, quick to make amendments to banking regulations in the financial industry to facilitate other people doing business in Cayman and people in the financial industry making money, we seem rather reluctant and hesitant to put in place protections for our own people. And I believe it's time to do that, and I believe that such mortgage legislation containing some of the things that I have mentioned will demonstrate to our people that the government is trying to protect some of their assets as well. And you know, Mr. Speaker, some of the benefits of the government putting in this legislation, the ability for equity release or reverse mortgage, would be that senior citizens could borrow money for health care, because a lot of them have houses that they built for $15,000, $20,000 in the 60s and 70s that is today worth hundreds of thousands of dollars. So they have lots of equity in it, but could reduce their health care costs to government. And also the financial support burden that the Minister of Community Affairs complained about last week that is growing in leaps and bounds. And, Madam Speaker, the UK, for instance, has just put in legislation to tighten lending policies for the banks, where they will only allow 80% of value maximum. And big consideration now is being paid to the customer's affordability, whether they can afford it or not, and 40%, only up to 40% of the income. We could put all of that in our mortgage legislation here, because most of the institutions here will not lend you unless we happen to know somebody who knows somebody, more than 80% of the value of the property. And most of them limit you to 40–45% of your income in terms of your payment. But we need to put it in legislation so that it forces the banks not to stretch these people out, and when they get in trouble, then they take their assets from them. Because, you know, Mr. Speaker, I also say that many of us Caymanians are trying to afford more house than we need. But again, if you go to buy one of Frank Hall low-cost houses, I think the cheapest one is $285,000. So that's not cheap. You know, and if you, an average, I think the average salary income here is below 3,000. 40% of that is 1,200. So, you know, we need to put these kind of things in regulations so that we can control all parties. But another big problem that the banks will tell you is the cost of the money that they lend. We can solve that problem easily. All we got to do is bring back percentage of the pension funds, which is cheap money, long term. And there shouldn't be any problem with saying to one of the commercial banks that the pension fund will put their money there for deposit. They can deposit it for 15, 20 years. But only allow them to, under the condition that they will on-lend it to Caymanians for home ownership at only 1% spread, 1% more than they pay in the fund. Because this thing that the Chamber of Commerce and the financial industry has created here called pensions, where the only people making out of this is the pension fund managers, and they're sending it to New York to be invested in failed companies in California on the basis that we're going to get bigger return than we can get locally. If it's in cash here, while you mightn't be making no big returns on it, you're not likely to lose it. Right? And you know, Madam Speaker, if the mother country, that's what we call her, right? Mother country, the UK, has mortgage legislation, we should be able to have it too. On 26th January 2015, the UK Treasury published new mortgage regulatory legislation. Canada, as I said earlier, has Mortgage and Housing Corporation Act 1985, 1935 Dominion Housing Act, 1937 the Home Improvement Loan Guarantee Act, 1944 the National Housing Act. Latest rules I found were July 9, 2012, effectively reduced the amortization period from 30 years for government-insured mortgages to 25 years due to encourage homeowners not to stretch themselves out too greatly. Also lowered the maximum for refinancing to 80% of the appraised value of properties from the current, from what was 85% before that. And this was all done to stabilize the Canadian housing market. So it is not communist, it is not socialist for government to intervene and have legislation which protects its people from these institutions. Now, Mr. Speaker, in doing my looking around the internet, came across a very appropriate article, Exercise of the Mortgage Power of Sale in Jamaica, a presentation to the Jamaican Bar Association by Alison Dunkley, now McLean, on June the 15th, 1997. And Mr. Speaker, in her introductory remarks, she said, the need to appreciate the extent and manner of the exercise of a mortgagee's power of sale has become of greater relevance because of the existing economic climate in which there is an increased ability, open brackets, some may say unwillingness, close brackets, on the part of a number of mortgagors to meet the monetary obligations of their mortgages. It also takes on added significance in the face of dilemmas surrounding some of the financial institutions and the consequent realization of securities. Now, Mr. Speaker, this problem of foreclosures is in the forefront as a direct result of our economic situation. What, therefore, is the determining factor in declining to exercise this power? It would appear that in a volatile market, there will be moves towards shading bad securities in an effort to regroup the outstanding debt balances. In an article entitled Mortgage Remedies by Ronald Greenspan QC, in which he examined the use of remedies of foreclosure and power of sale in Canada, he indicated that historically the remedy of foreclosure is preferred where property values are stable or rising. But with an uncertain market, exercise of the power of sale is preferred. However, within our jurisdiction, after all else fails, and particularly in an unstable economic climate, resort is had to the power of sale with foreclosure of law, by law, and practice being a last resort remedy. It may be that procedurally, this is less complicated means of securing repayment of the debt than proceeding further to foreclosure. Foreclosure does, from a mortgagee's perspective, present advantages in terms of vesting the fee simple and allowing the mortgagee to deal with it, e.g., subdividing for sale as lots. However, we must remember that building societies, which are among our primary lenders, are restricted under the Bank of Jamaica Building Societies Regulation 1995 from keeping land so acquired for a period in excess of 3 years unless the time has been extended by application. And Madam Speaker, she goes on to lay the foundation for the statutory basis of power of sale. In Jamaica, it's contained in the Registration of Titles Act. Here it's contained in our Registered Land Law. She deals extensively with notice period and how notice is supposed to be done. And I think that there is room for some improvement of that locally as well. No, I think it's very relevant to our situation here in Cayman, because she deals quite thoroughly with the mortgagee's duty to the mortgagor. And this is, rightly or wrongly, the perception of many people, Mr. Speaker, is that they are being treated unfairly by the banks. Now, whether that is an actual fact in what is transpiring, that is the perception that they get, especially when the process is so quick to reduce the value and take away their equity, but very rarely does it fall below what's owed to the bank. And if it falls below that, then they turn to the personal guarantee that the person has given them. And often that is personal and several. But here's what she says about the mortgagee's duty to the mortgagor. Having examined how the power of sale becomes exercisable, we should now cast our minds to the extent of the duty owed by a mortgagee. This is an area of competing formulations, and two main ones can be identified: English, Jamaican, second Australian. One of the most useful local decisions on this area, and generally on the power of sale, is Moses Drackett versus Rapid Vulcanizing Company Limited. The judgment of the late Canberra J. is a virtual treatise on the case law in the area and well worth pursuing. And Mr. Speaker, one of the problems we have in Cayman, is although we have 600 lawyers, very few of them practice law. They practice financial business. And they set up these precedents, and they get the secretary to clip a couple of pages of paper together, put them in an envelope and send them to the client, and they charge them a fortune for it. We don't have in Cayman what happens in places like Jamaica and other Caribbean territories, where there's a lot of testing of these cases in court, because that's how they earn QC. In those countries, here it's given by the governor, usually to most people who haven't earned it, but are they big in the financial industry and they made 100 million. But QCs never seem to be offered to Caymanians, and again, I never understood that, but I don't know what's involved in that and everything else. But because we don't have all of this local case history testing these things in our courts of law, this usually happens when they go after somebody who got money and they can afford a lawyer. Because, as we know, our lawyers here are not allowed to take things on percentage of what they get or anything like that. So most of them, when you go see them, they tell you, well, Mr. Miller, you need to put me in pocket. And you say, put you in pocket? I'm too big, get in your pocket. No, I mean you need to write me a check. or give me some cash, and that's usually $20,000 to $30,000 up front. So somebody in trouble with their mortgage usually can't afford a lawyer. But she says, briefly, the facts are that the plaintiff mortgagor owned land jointly with his mother in Jamaica. The mortgagor guaranteed a mortgage to the defendant, who was to supply labor and materials to build on the land. The mortgagor fell into arrears and the property was sold by auction for $6,400, which realized $117 for the mortgagor after repayment of the debt and attendant costs. 11 months later, the property was resold for $14,400 or 125% profit. The issue is focused on the sale at auction, whether it was properly conducted, and the duty owed by the mortgagee. The issue is far from being free of difficulty. The law has had to deal with two concerns. One, concern for the mortgagor and a need to protect him from a mortgagee recklessly disposing of his property, and two, enabling a mortgagee to recover his money from a defaulting mortgagor by realizing the security for the debt. The first approach was demonstrated in decisions such as Morit versus Anchor Revisionary Company Limited and Wolf versus Van der Ries, which can be summarized by saying that a mortgagee was bound to act with the same regard and prudence of the owner with a view to having a sale of the mortgagee property to the greatest advantage. The second approach is exemplified in the dicta of Chitty J. in Farah versus Farah, which is well known. A mortgagee exercising a power of sale is not a trustee of the power. He is bound to sell fairly and to take reasonable steps to obtain a proper price. He cannot be required to run any risk in postponing the sale or to speculate for the mortgagor's benefit. And then it goes on to say, if he willfully and recklessly deals with the property in such a manner that the interests of the mortgagor are sacrificed, he has not been exercising his power of sale in good faith. Over time, certain points have come to the fore, and Cranberry J highlighted these. One, a mortgagee should not enter into a conclusive sale. Two, a mortgagee might be held responsible if he or his auctioneer misdirected the property so that it fetched less when sold. A mortgagee would be liable if he took possession and misused the property, whereby reducing its value. The court further concluded that a mortgagee, in exercising his power of sale, does owe a duty to take reasonable precautions to obtain the true market value of the mortgaged property at the date on which he decides to sell it. So Madam Speaker, it would be interesting and to see if any of these properties that the banks have sold below the valuations of the owner or the valuations have actually been resold since that, and what price they were resold at. And the only way to track that would be probably through the land registry. And I guess it'll cost a small fortune to go there and look at the records. But it would be worth, I believe, somebody looking into it. And it says, she goes on to talk about sale to mortgagee. Suffice it to say that it is trite law that a mortgagee cannot sell the mortgaged property to himself. For a sale by person to himself is no sale at all, and the power of sale does not authorize the donee of the power to take property subject to it as a fixed price fixed by himself, even though such a price be the full value. The rule also applies to the following persons: an officer of the mortgagee, an attorney or the agent acting for the mortgagee in the sale. And Mr. Speaker, there has been suggestions that some of the people involved in the sales of these properties may in fact be selling them to companies that they may have an interest in, or to friends at those reduced prices. And the legislation should be quite clear if the government decides to do it, to prevent that sort of thing. Because if you're showing a house and the three people present happens to be the real estate agent, the lawyer for the bank, and somebody from the bank, and you hear the lawyer from the bank telling the prospective buyer that if they think the price is too high, just wait another month because they're going to lower the price again. That kind of thing, I think, goes against the grain of what Ms. Alison McLean is talking about here. And any legislation that we put in place needs to clearly prevent that sort of thing. Then she talks about auction, Mr. Speaker, versus private trading. Is a mortgagee bound to wait until a particular time before exercising the power of sale, either by auction or private trading? The authorities all make it clear that this is not so. A mortgagee is free to exercise the power at any time of his own choice, subject, of course, to the duty imposed on him to take reasonable steps to obtain the proper price. There is no obligation to sell at a particular time and thereby possibly reducing any loss which may be sustained by the mortgagor. It is usual for a mortgagee first put mortgage property up for sale at public auction, and if not successful in disposing of it there, to then proceed to sell by private trading. However, it is not a legal requirement that this course of events be adopted. Section 106 of the Registered Titles Law authorizes the mortgagee to sell by public auction or by private contract, which is similar to our RLL. The procedure referred to in the foregoing paragraph is submitted usually adopted out of an abundance of caution. And then she goes on to seek to have a lot of case history on that type. And Madam Speaker, I don't think it would be unreasonable for legislation to suggest that the property should not be sold for a certain percentage below what the property was valued at the time of mortgage, unless there are extenuating circumstances. Because if you real estate and houses in Cayman, Mr. Speaker, very rarely go down. I think if you look back at the history of real estate, it's more like a staircase. It levels off, goes up, levels off, it goes up. There's not much record of real estate and houses reducing in value in Cayman. So it is difficult for me as a legislature to accept that a house that was valued over $500,000 in 2009 can be valued at $265,000 in 2014 in a respected residential area. This is not a house that is in the one of the bad areas, as we would call it, right? This is in a very upscale, respected residential area. So the likelihood of that house reducing in value, short of it having no maintenance, all the windows being broken and having no doors, and et cetera, difficult to understand how it could depreciate in value by over $200,000. She talks a little bit about valuation reports, and she says, at first instance, Wolf J. was of the opinion that failure to obtain a prior valuation could not affect the price obtained at auction, as bidders do not make bids on the basis of prior valuations received by the mortgagee. Prima facie, the object of sale by auction is to give the world at large an opportunity of making an offer at the sale, with the hope that in so doing, the best price or the proper price or the true market value will be realized. In the absence of any allegation of fraud or negligence in supplying information as to the mortgaged property or impropriety in the conduct of sale, from which it can be inferred that but for such misconduct, a better price might have been realized. The highest bid at an auction must of necessity be deemed to be the best price. And, Madam Speaker, most of us tend to say, well, you know, the fair price of any product is what a willing purchaser will pay and a willing seller will sell. Well, the absent part of that formula is most of these foreclosures, the person is not a willing seller and they'd like to keep the house. And they're being forced to sell it and they're being evicted by the banks, which they have the authority to do under the mortgage agreement and the law. I just believe that as a government, we have a responsibility to these people to ensure that reasonableness is not just women fancy, but there are such things in law and regulation that insist that reasonableness be carried out in these cases. And then she talks about reserve price as well. Moses Dreckett is authority for the proposition that in a sale by auction, there is no obligation on the mortgagee to fix or have fixed a reserve price because he is entitled to accept the highest bid even if it is below the market value as indicated by a valuator. Guidelines. In sales by public auction, the following are therefore the pertinent guidelines. A mortgagee need not obtain a valuation of the property being sold, although this may be prudent. 2, a mortgagee need not set a reserve price. 3, in the absence of collusion or impropriety, the mortgagee is entitled to accept the highest bid as reflective of the true market value despite low bidding and poor attendance. One may question whether bidding at auction can represent the true market value. Traditional people bid low at these sales, so is this an accurate reflection of what the property can fetch on the market? Are the 20 or 12 persons present at an auction representative of the marketplace? Short of having a specific formula to apply, the answer seems to be this. The property having been exposed through the published notices has come to the attention of the persons who are willing to bid for it. They therefore represent the marketplace within which the property may be disposed of, and the bidding reflects the best price which can be obtained via this medium at this time. Well, one of the things I think that our law requires is publish it in the Gazette. And most of these Caymanians being foreclosed on don't get copies of the Gazette. They couldn't afford to subscribe to it if they wanted to. And I don't believe we sent them to the post offices like we used to before. So maybe if the government accepts the idea of drafting mortgage legislation, we will have some other form, whether it's in a daily newspaper. Well, some people might say, well, that's too embarrassing to the people involved, but at least it would give it wider exposure than the Gazette notice. Then she talks a little bit about private treaty. While the duty is the same, it seems to be harder to discharge when selling by this means. The extent of this is seen in the decision in John Adams. In the case, the bank sold a mortgage property by private treaty. It accepted an offer of $395,000 and declined to accept a higher offer from a purchaser identified by the mortgagor. A valuation report was obtained by the mortgagee in December 1998, who subsequently made an agreement for sale by private treaty in June 1989. It did not advertise the property. The court determined that the mortgagee had not discharged his duty. The court spoke to the need to expose the property to prospective purchasers in the open market. And, Madam Speaker, one of the things that the people perceive that is happening is that the banks are marketing these houses through specific real estate agencies to specific people. And if that can be documented, we need to do something about it. And not because one real estate agent sells more of these foreclosures than another means that there's any collusion in place, but it could be. And if you see them all at a certain bar together smoking cigars, and all three people are there represented, they might not just be talking about the sunshine and the weather. And there are people who claim that they have evidence of this. And there are people who, in this process, who also claim that they believe the civil servants and land and registry are in some way connected to this, in that they are accepting these reduced valuations. And I gave you the case earlier where they accepted the size of the square footage of a house that was substantially less than the actual square footage of the house. And all the government land register person had to do was go upstairs to planning, get a copy of the plan, they will see that the house has upstairs. But if you look at it as a satellite photo, it's hard to tell that the house is upstairs looking from the roof down. But they accepted the reduced valuation, and by that the person was allowed to get the benefit of stamp duty waiver. But normally, you know, the opposite happens in the land registry, in that they often try to get more in their evaluations than what you actually paid for the property. And if they value it more, you have to pay on their value, not on what you paid for it. Even though all of your documentation might say you paid $200,000 for it, if they value it at $300, the stamp duty is calculated under $300. So I think we need to, the government need to look in to that possibility, and I believe that the people involved would be willing to provide the relevant government agency with the information that they have. Because, Mr. Speaker, a house is either 4,500 square feet or it's 3,600. It can't be both. But you can see any evaluation based on square footage, how the 3,600 would be substantially lower than the 4,500. She also goes on, Mr. Speaker, to make suggest some guidelines. But sticking to the valuation reports, she says that in John Adams, the mortgagee obtained a valuation report of the open market value in December 1980 and sold 6 months later without further valuation or advertisement. However, this was not sufficient to discharge the duty. Another decision worth examining is that a 1986 English Court of Appeal in Predith, I don't know why they make these names so difficult to pronounce, and Castle Phillips Finance Company Limited and Arnor. In this case, a mortgagee disposed of property by private treaty. The valuator was instructed to carry out a crash sale valuation, which connotes a more rapid sale than forced sale. This would have given the mortgagee the lowest valuation. The court affirmed that the mortgagee had failed to obtain a valuation on the basis which the exercise of reasonable care would require, and in compliance with its duty to the mortgagor, that is current market value. So regard must be had not only to the fact of obtaining a valuation report, but also to the basis of the report. The cases appear to consider whether the report is for A, current market value versus another value, such as crash sale. 2, the property in its existing state or in the future state. For example, in instances in which construction is underway, is the value reflected of the incomplete or the anticipated completed state? This was considered in the Zachariah Sharif case. The purpose of sale or otherwise, e.g. loan financing. Advertising. The court also examined the steps are taken to advertise the property and bring it to attention of prospective purchasers. The mortgagee did not advertise before selling by private treaty. This, coupled with a misdirection on his part as to whether or not there was a binding contract in place at the time the mortgagor identified a purchase offering a higher price led the court to conclude that the standard of the duty of care had not been met. Similarly, in pre-death, the mortgagee failed to instruct any agents to expose the property, and his own efforts were accepted by the Court of Appeal as wholly inadequate. Getting back to what I said earlier, Mr. Speaker, maybe we need to, in this legislation, include some other form of notice other than in the Gazette that gives it more exposure. And the MLS is a very restricted thing, because if you don't happen to be a member of Cerebro, I don't think you can get access to their listings. And if you think it's difficult to get a job for Cayman, to get a job in the financial industry, try the real estate industry, you know, that's a lockdown market. And that needs to be investigated. Cerebro is supposed to be a non-profit organization which supposedly have collected billions of dollars over the last decades, because every sale that they make, certain fees go into that, and there's no public accounting of the money and where it is. But if you apply to them for a job, they tell you you got to be trained. So, okay, I'd like to sign up to your course. Well, you can't sign up to the course unless you have a job. So, kind of difficult to get in. And if you go and open your own thing, hang up your own shingle, then they badmouth you to their clients. She suggested some guidelines. What, therefore, is required before entering into a sale by private treaty? The following guidelines are suggested. 1, obtain a valuation report indicating current market value and reflective of the mortgage property in its current state and condition. 2, expose the property to open market by adequate advertising, listing with realtors, accurate advertising in newspaper, akin to the method utilized by auctioneers over a reasonable period of time. Note that sales by auction usually have at least 4 insertions. 3, be cognizant and have regard to offers procured by the mortgagor or otherwise prior to the entry into a binding agreement for sale. Then she talks a little bit about what happens to the funds when the bank actually gets more than they own. And there are some companies here that some properties are sold for more than the value of the mortgage, and the client is having difficulties getting the difference from the banks. She says Section 106 of the RTA allows the mortgagee to sell once there has been default and provides as there shall be no liability to the mortgagor for any loss sustained. It further provides that no purchaser shall be bound to see or inquire such default shall have been made, or whether such notice shall have been served or otherwise into the propriety or regularity of such sale, and any person damnified by an unauthorized or improper or irregular exercise of the power shall have his remedy only in damages. So, Madam Speaker, what I'm seeking the government to do is not rocket science. There are many examples we can use. It is not breaking the mold. It is just something that I believe that we could do, which would give the people we represent some additional comfort to what exists in the registered land law. I ask the government to consider supporting the motion. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? I call on the Honorable Minister of Financial Services.
Mr. Speaker, thank you very much. Good morning.
You need this done? You want
Yes,
to start?
thank you.
I can't cross.
Mr. Speaker, I rise on behalf of the government to respond to the private member's motion number 4 of 2015-16, brought by the member from Northside, and seconded by his colleague. Mr. McLean. Mr. Speaker, I apologize. The member is correct. I should refer to him as a member from East End. I think he would be elected if he was here. So, sorry, I was looking at the motion when I referred to that. Mr. Speaker, the motion was read by the member from Northside, and in his first recital, he says many Caymanians are experiencing difficulties with their mortgages and in some cases are losing their equity in the current foreclosure regime. There are certainly significant elements of truth in that. Perhaps not as many as we might think, but there are Caymanians that are experiencing significant difficulties. I'll talk about some statistics a bit later. But Mr. Speaker, whether it's 100, caught myself, whether it is 100 Caymanians or 5 Caymanians, it is still a problem for those individuals. Statistics don't mean anything to those people who are going through the problem. And we are certainly cognizant and sympathetic in respect to that. Mr. Speaker, the second recital of the motion refers to, well, says, whereas there is no current mortgage legislation in place. Mr. Speaker, that, unfortunately, is a recital which is not accurate. Perhaps the member would say that there's nothing called mortgage legislation. But the registered land law, Mr. Speaker, deals with the form of security that we have in Cayman, which is a legal charge. That is the form of security we use in relation to securing or utilizing property to secure loans and borrowings. And Mr. Speaker, that is reflected in Division 3 of the Registered Land Law between sections 64 and 82. So there are a total of 18 different sections. Mr. Speaker, I started off saying that the government is sympathetic to the issue, and I will confirm that the government will or is prepared to support the motion. But we will need to amend the recital suggesting that there is no more mortgage legislation. Because while it's maybe generally referred to as a mortgage, what we have here is, strictly speaking, a legal charge. And there is a distinction. So, Mr. Speaker, with your permission, I would like to move an amendment to the motion to revise that, or to remove, rather, that recital so that we can deal with continue to deal with the amended motion. Mr. Speaker, perhaps we can have an indication from the member from North Side whether he's okay with that.
I don't agree with him. He won't amend it, he can amend it. That's file amendment, give notice, file amendment. I speak, we have notice here. You had this now a long time, you could have filed amendment a long time, you know. We have to do it according to the rules. You got to do it according to the rules too. File your amendment, ask the speaker to give you notice. Let me see what it is. Can't get up here and talk about it. Splitting hairs if I remember look back.
Mr. Speaker, based on the indications from the member from North Side, I think it would be useful at this point if you would indulge us with a short break, that I may have a discussion with the member, see if we can resolve this particular issue to be able to move forward with the motion.
We'll take a break until 12:20.
I'm obliged, sir.
Lunch now, Speaker? Because it's not going to be done 5 minutes, you know.